If we are responsible, the future will be good for the future generations. Bharatiya Nagarik Suraksha Sanhita, BNSS, 2023. Chapter 14, Jurisdiction of the Criminal Courts in Inquiries and Trials, Sections 199 to 212. Chapter 14 of the Bharatiya Nagarik Suraksha Sanhita, BNSS, 2023, outlines the jurisdictional framework governing criminal courts in India concerning inquiries and trials. Sections 199 to 212 provide detailed guidelines on which courts have the authority to handle various offences, ensuring a structured and efficient judicial process. This chapter is essential for maintaining the orderly administration of justice and ensuring that cases are tried by the appropriate courts. Section 199, Ordinary Place of Inquiry and Trial. Section 199 stipulates that every offence shall be inquired into and tried by a court within whose local jurisdiction it was committed. Key points. Local jurisdiction emphasizes the principle of territorial jurisdiction, where offences are handled by local courts. Convenience ensures convenience for witnesses and parties involved, facilitating the collection of evidence and testimony. This provision is fundamental for the orderly and efficient administration of justice. Section 200, Place of Inquiry or Trial. Section 200 addresses cases where it is uncertain within which jurisdiction an offence was committed. It allows the trial to take place in any of the local areas where any part of the offence occurred. Key points. Multiple jurisdictions accommodates offences that span multiple jurisdictions. Flexibility provides flexibility in determining the place of inquiry or trial. This ensures that jurisdictional ambiguities do not hinder the prosecution of offences. Section 201, Offence triable where act is done or consequence ensue. This section specifies that offences can be tried either where the act was done or where its consequence ensue. Key points. Dual jurisdiction recognizes that some offences have effects that occur in different locations. Victim consideration takes into account the location of the victim and the impact of the offense. This provision ensures comprehensive jurisdictional coverage. Section 202, Place of trial where act is an offense by reason of relation to other offense. Section 202 allows for the trial of an offense at the place where the act is committed if it is an offense due to its relation to another offense committed elsewhere. Key points. Related offenses addresses interconnected offenses that span different jurisdictions. Efficient prosecution ensures related offences are tried together for efficiency. This facilitates the coherent prosecution of related offences. Section 203, Place of trial in case of certain offences. This section specifies that certain offences may be tried in specific places designated by the law, overriding the general rules of jurisdiction. Key points. Special jurisdiction applies to offences requiring special judicial consideration. Legislative designation allows for legislative flexibility in designating trial venue. This ensures that specific offences receive appropriate judicial attention. Section 204, Offences committed by letters, etc. Section 204 addresses offences committed by means of letters, electronic communication, or other means sent from one place to another. It allows for the trial to be held either at the place where the communication was sent or received. Key points. Electronic crimes adapts to modern communication methods. Dual venue provides flexibility in choosing the trial venue. This provision is crucial for handling cybercrimes and communication-related offences. Section 205, Offence committed on journey or voyage. This section deals with offences committed during a journey or voyage, allowing the trial to be held at any place through which the accused person or the victim passes in the course of the journey. Key points. Travel offences addresses crimes occurring in transit. Flexible venue ensures accessibility and convenience for the trial. This ensures that justice can be administered effectively for offences committed during travel. Section 206, High Court to decide, in case of doubt, district where inquiry or trial shall take place. Section 206 grants the High Court the authority to decide the appropriate district for inquiry or trial in cases of jurisdictional doubt. Key points: judicial discretion allows the High Court to resolve jurisdictional disputes. Clarity and authority provides a clear decision-making process for jurisdictional issue. This ensures that jurisdictional ambiguities are resolved efficiently. Section 207, power to issue summons or warrant for offense committed beyond local jurisdiction. This section empowers courts to issue summonses or warrants for offences committed beyond their local jurisdiction. Key points: extended authority allows courts to act on offences outside their immediate jurisdiction. Legal reach ensures offenders can be brought to justice regardless of location. This provision enhances the ability to prosecute cross-jurisdictional offences. Section 208, receipt of evidence relating to offences committed outside India. Section 208 permits the reception of evidence in Indian courts for offences committed outside India, provided such evidence is relevant to the case being tried. Key points: international jurisdiction accommodates evidence from foreign jurisdictions. Relevance ensures only pertinent evidence is considered. This is essential for handling international crimes and ensuring comprehensive justice. Section 209, procedure when offender is unknown. This section outlines the procedure to be followed when the identity of the offender is unknown. It allows for inquiries and the issuance of orders to uncover the offender's identity. Key points: unknown offenders addresses situations where the offender is not immediately known. Investigative measures empowers courts to facilitate identification. This ensures that justice is pursued even when initial details are unclear. Section 210, transfer of cases. Section 210 allows for the transfer of cases from one court to another for reasons such as convenience, fair trial, or other sufficient grounds. Key points: case transfer facilitates the transfer of cases to appropriate venue. Fair trial ensures that cases are tried in the most suitable and just environment. This provision enhances the flexibility and fairness of the judicial process. Section 211, procedure when offender is outside India. This section details the procedure for handling cases where the offender is outside India, including steps for extradition and cooperation with foreign authorities. Key points: extradition addresses international cooperation for bringing offenders to justice. Legal framework provides a structured approach for dealing with offenders abroad. This is vital for prosecuting international crimes and ensuring offenders are held accountable. Section 212, receipt of evidence and execution of processes from outside India. Section 212 facilitates the receipt of evidence and the execution of legal processes from outside India, ensuring that cross-border legal cooperation is effective. Key points: international evidence allows for the use of foreign evidence in Indian courts. Process execution ensures that legal processes can be executed internationally. This provision supports comprehensive international legal cooperation. Summary: Chapter 14 of the BNSS 2023 establishes a clear and detailed jurisdictional framework for criminal courts in India concerning inquiries and trials. Through sections 199 to 212, it addresses various scenarios, including territorial jurisdiction, offences spanning multiple areas, international crimes, and offences committed during travel. By providing clear guidelines on jurisdiction, this chapter ensures that criminal cases are tried in the appropriate courts, facilitating efficient and fair administration of justice. It enhances the ability of the judicial system to handle complex jurisdictional issues, ensuring that offenders are brought to justice and victims receive fair treatment. Stay informed. Live in comfort.